Good morning, this is your Kelso Report for Tuesday, May 15th. I'm your host, Clark Kelso, with a bit of a cold today. Well, we have cases dealing with bankruptcy, the Individuals with Disabilities Education Act, and California's overtime law. We begin with bankruptcy in the United States Supreme Court. Under Chapter 12 of the Bankruptcy Code, farmer debtors may treat certain claims owed to a governmental unit resulting from the post-petition disposition of farm assets as dischargeable unsecured liabilities. One such claim is for any tax incurred by the estate. Well, the question presented to the court in Hall v. United States was whether a federal income tax liability resulting from individual debtors' post-petition sale of a farm is incurred by the estate and thus dischargeable. In a close 5-4 decision, the majority held that the federal income tax liability resulting from the sale was incurred by the individual debtors, but was not incurred by the estate. Therefore, the taxes were not collectible nor dischargeable in the Chapter 12 plan. The dissenters here were more concerned with the purposes of the chapter to provide relief to farm debtors than they were with the technical interpretation of the phrase incurred by the estate. In essence, the dissent was willing to treat the individual farmer and the bankruptcy estate as merged for purposes of interpreting these provisions. There is, in my judgment, no question but that the dissent's interpretation is more faithful to the likely congressional purpose. But the majority opinion is more faithful to the language in the statutes. So a victory of plain meaning over purpose. And incidentally, if you're wondering why the Supreme Court was wading into this, there was a split of authorities between the circuits. Otherwise, I don't think the Supreme Court would have taken this sort of a case. Next, we turn to the Ninth Circuit and education law. The Individuals with Disabilities Education Act does not contain a provision authorizing a compensatory damage remedy. Instead, the IDEA creates an elaborate administrative enforcement scheme where judicial review of administrative action is the primary form of judicial relief. Nevertheless, the District Court in Oman versus Portland Public Schools recognized a private cause of action under IDEA in Section 1983 for nominal damages only, reasoning that such a remedy would provide an additional compliance mechanism without raising the specter of large compensatory awards. The Ninth Circuit predictably reversed. While the District Court's analysis suggested Congress itself might want to establish such a remedy, as the Ninth Circuit panel explained, this does not give federal courts license to invent a cause of action. Finally, we have an overtime case under Court of Appeal, California Court of Appeal. When a family hires an employee to care for an elderly person in his or her home, is that employee entitled to overtime pay? Well, under California law, the answer depends on the type of work performed by the caretaker. If the employee performs work of a personal attendant, defined to mean a person employed to supervise, feed, or dress the client, the caretaker is exempt from overtime pay requirements. However, if the caretaker performs a significant amount of work in addition to these tasks, the caretaker is not exempt from overtime pay requirements. And, in addition, if the caretaker is a registered nurse employed to engage in the practice of nursing in the home, nurses are not exempt from overtime pay. Well, with this background, in Cash versus Wynn, the issue presented was whether the attendant exemption is applicable to a caretaker who performs any form of healthcare-related services, not just registered nursing. In other words, the caretaker in Cash wanted to extend the registered nurse rule to all caretakers who perform any healthcare services. The Fourth District rejected this argument, correctly noting that if the Industrial Wage Commission and wanted to extend overtime pay to all caretakers who perform any healthcare related service, it certainly would not have drafted its applicable wage order focused only on registered nurses. And that's it for today's Kelso Report. Have a great day in the law.